The day I woke up to find a bright orange violation notice stapled to my garage door was the day I realized my peaceful life in Anchorage, Alaska, was about to become a living nightmare. I stood there in my driveway, still holding my coffee mug, staring at the piece of paper flapping in the frigid January wind. The notice was from the Mountain View Estates Homeowners Association, and it informed me that I had 72 hours to remove the snow machine from my driveway or face a $500 fine. After that, the fines would increase by $250 per day until compliance was achieved. My name is Zachary Yates, and I had lived in this house for 3 years without a single problem. I bought the place specifically because I could keep my snow machine accessible during the winter months. Alaska without a snow machine is like living in Florida without air conditioning. It just does not make sense. I used that machine almost daily during winter to get to work when the roads were impassable, to check on my elderly neighbor down the street, and to haul supplies when my truck could not handle the terrain. I ripped the notice off my garage door and stormed inside to grab my phone. The HOA had never mentioned anything about snow machines in the 3 years I had been parking mine in the exact same spot. Nothing had changed. My machine sat right where it always had, on the left side of my driveway near the garage door. The number for the HOA management office went straight to voicemail. I left a message that probably sounded angrier than I intended, but I was furious. I had reviewed every single page of the HOA rules when I bought this house. There was nothing about snow machines. The only vehicle restrictions mentioned boats, RVs, and commercial trucks, and even those had specific guidelines about where they could be parked. I went to work that day unable to focus. I was a surveyor for a land development company, which meant I understood property lines, easements, and legal descriptions better than most people. That knowledge was about to become very useful. When I got home that evening, I found my neighbor, Tom, standing at the end of my driveway, looking at something on his phone. Tom was in his 60s, retired from the oil industry, and had lived in the neighborhood since the development was first built 15 years ago. "You get one of these too?" I asked, holding up my orange notice. Tom looked up and shook his head. "Nope. But I heard Karen Patterson was going door to door yesterday taking photos of anything she thought violated the rules." Karen Patterson. Of course. She had been elected HOA president 6 months ago, and since then, she had made it her personal mission to turn our quiet neighborhood into some kind of pristine suburban paradise that looked like a movie set. She had sent out notices about trash can placement, lawn ornaments, and even the color of curtains visible from the street. "She cannot just make up new rules," I said. Tom shrugged. "She seems to think she can. Jim down the street got a notice about his pickup truck. Says it is too old and needs to be parked in the garage. The thing is only 5 years old." I went inside and pulled out my copy of the HOA covenants, conditions, and restrictions. I read through every single page again, more carefully this time. There was absolutely nothing about snow machines. The vehicle section specifically listed prohibited vehicles, and snow machines were not on the list. The next morning, I called the HOA management office again. This time, someone answered. A bored-sounding woman named Linda told me that the HOA board had voted to amend the rules at their last meeting. "You cannot just amend rules without notifying homeowners," I said, trying to keep my voice level. "State law requires at least 30 days' notice and a vote." Linda sighed like I was the 10th person to call her that morning with the same complaint. "You would need to take that up with the board president, Karen Patterson. I can give you her number." I took down the number and called immediately. Karen answered on the third ring, her voice dripping with false sweetness. This is Karen. Mrs. Patterson, this is Zachary Yates from Mountain View Estates. I received a violation notice about my snow machine, but I cannot find anything in the HOA rules that prohibits them. Oh yes, Mr. Yates. Your property was one of several that were flagged during my neighborhood inspection. The snow machine is an eyesore and decreases property values for everyone in the community. But there is no rule against it. There is now. The board voted unanimously to prohibit all recreational vehicles from driveways. They must be stored in garages or off-site. When did this vote happen? At our last board meeting, 3 weeks ago. I never received notice of any rule change. The minutes are posted on the community website, Karen said, her voice taking on an edge. Homeowners are responsible for staying informed. State law requires written notice to all homeowners for rule amendments, I said. You cannot just post something online and call it proper notice. The rule has been implemented, Mr. Yates. You have 72 hours to comply or face fines. If you wish to dispute this, you can request a hearing with the board. Fine. I request a hearing. The next scheduled board meeting is in 6 weeks. 6 weeks. The fine would be thousands of dollars by then. Then I suggest you comply with the notice and we can discuss the matter at the hearing. She hung up before I could respond. I sat there staring at my phone, blood pressure rising. This was insane. I had never dealt with an HOA president who so blatantly ignored the rules she was supposed to enforce. But if Karen wanted to play hardball, she had picked the wrong person to mess with. That evening, I started going through my property documents. I had all the paperwork from when I bought the house, the title report, the survey, the deed, and all the closing documents. I spread everything out on my dining room table and began reviewing the legal description of my property. Something caught my eye. The survey showed my property line extending several feet beyond where I had always assumed it ended. According to the plat map, the left side of my driveway, where I parked my snow machine, was actually outside the platted subdivision boundary. That could not be right. I looked closer. The subdivision plat showed the edge of Lot 27, my lot, ending at a point that would put about 8 feet of my driveway outside the official subdivision boundary. If that was accurate, that portion of my driveway was not subject to HOA rules at all. I needed to verify this. The survey I had was from 15 years ago when the house was built. Property lines do not change, but surveys can have errors. As a surveyor myself, I knew better than to rely on a single document without field verification. The next morning, I called my boss and asked if I could take a few hours to do a personal survey. He agreed, knowing my situation with the HOA. I loaded up my equipment and headed home midday. I spent 3 hours that afternoon taking measurements, checking benchmarks, and verifying the property corners. Every measurement I took confirmed what I had seen on the plat. The left side of my driveway was not part of the subdivision. It was part of an odd remnant parcel that had never been included when the development was platted. According to the county records I pulled that evening, that remnant parcel was still owned by me. It had been deeded to me separately from the subdivision lot, probably because the developer did not want to deal with the complications of having a non-conforming piece of land within the plat. The title company had bundled it into my purchase without much explanation, and I had never paid attention to it. This changed everything. If my snow machine was parked on property outside the subdivision, the HOA had no jurisdiction over it whatsoever. Karen Patterson had not just overstepped her authority. She had tried to enforce rules on property the HOA did not control. I printed out all my documentation, including my new survey, the plat map, and the deed showing ownership of the remnant parcel. Then I called Karen Patterson. Mrs. Patterson, Zachary Yates again. I have completed a survey of my property and discovered that the area where my snow machine is parked is not part of the subdivision plat. It is a separate parcel that is not subject to HOA rules. There was a long pause. That is absurd. Your entire property is part of Mountain View Estates. No, it is not. I have a current survey and the recorded deeds. I am happy to provide copies to the board. Mr. Yates, I do not know what you are trying to pull, but this does not change anything. The violation notice stands. Actually, it changes everything. If you continue to pursue this violation for property outside HOA jurisdiction, you would be acting beyond your authority. I suggest you consult with the HOA attorney. I do not need to consult with anyone. You will comply with the notice, or you will be fined. Then I guess we will see each other in court. I hung up. I was not bluffing. If Karen wanted to push this, I was prepared to fight it. But I hoped the HOA attorney would talk some sense into her once they reviewed my documentation. The 72 hours passed. I did not move my snow machine. On the morning of the fourth day, I found another notice on my door. This one informed me that I was being fined $500 and that I now had 24 hours to comply before additional daily fines began. I scanned the notice and emailed it to a real estate attorney I knew named Daniel Wright. I also sent him all my property documentation and my survey. He called me back within 2 hours. "This is interesting," Daniel said. "You are absolutely right about the property line. That section of your driveway is not part of the subdivision. The HOA has no authority there. So what do I do? Write a formal response to the HOA citing the property survey and the deed. Clearly state that the area in question is not subject to HOA jurisdiction and demand they rescind the violation and any fines. Send it certified mail so you have proof they received it. And if they do not rescind it, then you file a lawsuit for declaratory judgment. A judge will review the property documents and issue a ruling that the HOA has no jurisdiction. You might also have grounds for harassment if they continue after being properly notified." I drafted the letter that evening, attaching copies of all relevant documents. I kept the language professional but firm. The letter explained the property boundary issue, cited the specific deed and survey, and demanded that the HOA immediately cease all enforcement actions regarding the snow machine. I also requested reimbursement for the survey costs and attorney consultation fees. The next morning, I sent the letter via certified mail to both Karen Patterson and the HOA management company. Then I waited. 3 days passed without a response. Then, on the fourth day, I received an email from Karen. The email was curt and dismissive. She wrote that the HOA board had reviewed my claim and rejected it. According to Karen, any property used in conjunction with a subdivision home was subject to HOA rules, regardless of technical boundary lines. She stated that the fines would continue to accrue, and that if I did not pay within 30 days, the HOA would file a lien against my property. I forwarded the email to Daniel immediately. He called me within the hour, and I could hear the anger in his voice. This is one of the most ridiculous things I have ever seen from an HOA board. They clearly did not consult with an attorney, or if they did, they ignored the advice. We need to file suit immediately. How long will that take to file? A few days. To get a hearing? Probably a few months, but we can request an expedited hearing given that they are threatening ongoing fines. In the meantime, do not pay anything. Keep documenting everything they send you. Daniel drafted the lawsuit over the next week. The complaint sought a declaratory judgment that the HOA had no jurisdiction over the remnant parcel, an injunction preventing further enforcement actions, and damages for harassment and attorney fees. We filed it in Anchorage Superior Court on a Tuesday morning. The HOA had 30 days to respond to the lawsuit. During that time, I continued to receive violation notices and updated fine amounts. Karen even sent a letter threatening to have my snow machine towed if I did not remove it voluntarily. I forwarded everything to Daniel. About 3 weeks after we filed the lawsuit, I got a call from a number I did not recognize. I answered cautiously. "Mr. Yates, this is Gregory Campbell. I am an attorney representing the Mountain View Estates HOA. I have been retained to handle the lawsuit you filed." "Okay. I have reviewed the property documents you submitted, and I have some concerns about the position the board has taken. Would you be willing to meet to discuss a resolution?" "What kind of resolution?" "I would like to propose that the HOA formally acknowledge that the remnant parcel is not subject to HOA jurisdiction and rescind all violations and fines. In exchange, you would agree to dismiss the lawsuit without seeking damages. I have already incurred attorney fees and survey costs." "I understand. The HOA would be willing to reimburse you up to $2,000 for reasonable costs incurred in defending this matter." I told Gregory I would discuss it with my attorney and get back to him. When I called Daniel, he laughed. Their attorney saw the property documents and immediately realized they have no case. Karen probably did not consult him before starting this mess. 2,000 is low, but it might not be worth the time and cost of litigation to get more. It is your call. I thought about it for a day. Part of me wanted to drag this out and make Karen face the consequences of her arrogance. But the practical side of me knew that settling was faster and less stressful. I called Daniel back and told him to accept the offer, but to add one more condition. Karen Patterson had to personally sign the agreement acknowledging the property boundary issue. Gregory agreed, though he sounded reluctant. 2 weeks later, I received a settlement agreement in the mail. The document clearly stated that the remnant parcel was not part of the subdivision and was not subject to HOA jurisdiction. It rescinded all violations and fines. It included a check for $2,000. And at the bottom, I saw Karen Patterson's signature, looking noticeably shaky compared to the other signatures on the page. I thought that would be the end of it. I was wrong. About a month after the settlement, I came home from work to find that someone had spray painted the word "violator" across my garage door in bright red letters. I immediately called the police and filed a report. The officer who responded took photos and a statement, but without cameras or witnesses, there was not much they could do. I knew it was Karen. I could not prove it, but I knew. The timing was too convenient, and the word choice matched her accusatory tone from all our previous interactions. I called Daniel and told him what happened. "Document everything," he said. "Take photos, keep the police report. If anything else happens, we might be able to get a restraining order." I installed security cameras the next day. 2 on the front of the house, 1 covering the driveway and 1 covering the garage door. They were high-definition cameras with night vision and cloud storage. If anyone came near my property again, I would have video evidence. 2 weeks went by without incident. I started to think maybe the vandalism had been a one-time thing, a final act of petty revenge. Then, one evening in early March, my cameras caught something. It was just after midnight. A car pulled up slowly in front of my house and parked on the street. A woman got out, looked around nervously, and walked quickly toward my driveway. She was carrying something in her hand. As she got closer to the camera, I could clearly see her face illuminated by my porch light. Karen Patterson. She walked right up to my snow machine and started doing something to it. The angle made it hard to see exactly what, but her body language suggested she was tampering with it. She spent about 2 minutes there, then hurried back to her car and drove away. The next morning, I went out to check my snow machine. Karen had poured sugar into the gas tank. It was an old trick, one designed to ruin an engine. If I had started the machine without checking, the sugar would have caused serious damage. I immediately saved the video footage and called the police. This time, when the officer arrived, I had evidence. I showed him the video on my laptop. His expression turned serious as he watched Karen tampering with my property. "That is pretty clear," he said. "Have you had any other issues with this woman?" I told him everything. The HOA dispute, the lawsuit, the settlement, and the spray paint incident. He took notes and made copies of the video. "I am going to file a report for criminal mischief and possibly vandalism. The district attorney will decide whether to press charges. In the meantime, I would recommend getting a restraining order." "Will the video be enough for that?" "Should be. You have clear evidence of her trespassing and damaging your property. A judge should grant at least a temporary order." I called Daniel again. He had a contact in family law who handled restraining orders. By the end of the week, I had filed a petition for a stalking protective order against Karen Patterson. The petition included the video evidence, photos of the spray-painted garage door, and a detailed timeline of all our interactions. The court granted a temporary order immediately and scheduled a hearing for 2 weeks later. The temporary order prohibited Karen from coming within 100 feet of me or my property. The police served her with the order that afternoon. The response was immediate and dramatic. That evening, I received an email from Linda at the HOA management company. The email informed me that Karen Patterson had resigned as HOA president, effective immediately, due to personal reasons. The vice president, a man named Richard Schneider, would be taking over until the next election. I felt a grim satisfaction. Karen had finally faced consequences for her actions. The hearing for the permanent restraining order was set for a Thursday morning. I took the day off work and met Daniel at the courthouse. Karen was there with her own attorney, a nervous-looking young man who seemed out of his depth. The hearing lasted about 45 minutes. I testified about everything that had happened. My attorney played the video footage of Karen tampering with my snow machine. The judge watched it twice, her expression growing increasingly stern. Karen's attorney tried to argue that she had been acting in her capacity as HOA president to enforce community rules. The judge cut him off. "Counselor, I have reviewed the settlement agreement. The HOA explicitly acknowledged that it has no jurisdiction over the property in question. Even if it did, tampering with someone's personal property in the middle of the night is not a legitimate enforcement action. It is criminal mischief." Karen tried to speak, but her attorney shushed her. The judge issued a permanent stalking protective order, valid for 1 year. Karen was prohibited from coming within 300 feet of me or my property, and from any form of contact, direct or indirect. As we left the courtroom, I overheard Karen arguing with her attorney in the hallway. She was insisting that she had done nothing wrong, that I was the one causing problems in the neighborhood, that the judge was biased. Her attorney looked exhausted. I went home feeling like I could finally move on with my life. The restraining order was in place. Karen was no longer HOA president, and my property rights had been legally established. I could park my snow machine wherever I wanted on my own land without interference, but the story was not quite over yet. About a week after the restraining order hearing, I got a call from Detective Sarah Morrison with the Anchorage Police Department. She asked if I could come to the station to discuss the criminal case against Karen Patterson. I drove to the police station that afternoon and met with Detective Morrison in a small conference room. She was in her 40s, professional and direct. "Mr. Yates, the district attorney has decided to file criminal charges against Karen Patterson for criminal mischief in the 3rd degree. The video evidence you provided was very helpful. However, we have some additional information that I wanted to discuss with you." "What kind of information?" "After we served her with the restraining order, we started getting calls from other residents in your neighborhood. It turns out you were not the only person she was targeting. 3 other homeowners have come forward with complaints of harassment and property damage. One man found his tires slashed after he refused to remove a basketball hoop from his driveway. Another couple discovered someone had killed their flower garden with herbicide after they painted their front door a color Karen disapproved of. You have evidence that Karen did those things. We are working on it. But given the pattern of behavior and your video evidence, we are taking the complaint seriously. I wanted to let you know because her attorney might try to claim that you are part of some kind of neighborhood conspiracy against her. That is ridiculous. I agree. But I wanted you to be prepared. The criminal case moved slowly through the system. Karen pleaded not guilty and demanded a trial. Her attorney tried to get the video evidence suppressed, arguing that my cameras violated her privacy. The judge denied the motion, pointing out that Karen had no expectation of privacy while trespassing on someone else's property. During this time, the Mountain View Estates HOA underwent some significant changes. Richard Schneider, the new president, sent out a letter to all homeowners apologizing for the previous board's overreach. He announced that the board would be reviewing all recent rule changes and violations to ensure they were properly implemented. He also invited homeowners to attend the next board meeting to voice concerns. I went to that meeting. About 40 other homeowners showed up, which was apparently unheard of for a regular board meeting. Person after person stood up to complain about Karen's reign as president. She had issued violations for everything from lawn height to decorative flags to the type of mulch people used in their gardens. Many homeowners had paid fines rather than fight her, not realizing they had legal options. Richard looked genuinely shocked by the stories. He promised to refund any fines that had been improperly assessed and to implement a new appeals process for violations. He also said the board would be working with an attorney to ensure all future rule changes followed proper procedures. One woman stood up and asked about the criminal charges against Karen. Richard said he could not discuss ongoing legal matters, but that the HOA was fully cooperating with law enforcement. He also mentioned that the HOA's insurance company was investigating whether Karen had exposed the association to liability for her actions. The trial was scheduled for late May. I was subpoenaed to testify, which I expected. What I did not expect was the media attention. A local news reporter had somehow gotten wind of the story and reached out to me for an interview. Apparently, HOA president arrested for property damage was newsworthy. I agreed to the interview, figuring it might help other people who were dealing with overbearing HOAs. The segment aired on the evening news 2 days before the trial. The reporter did a good job presenting the facts, including showing part of the video footage. They also interviewed a real estate attorney who explained property rights and HOA limitations. Karen's attorney was furious. He tried to get a mistrial before the trial even started, claiming the media coverage made it impossible for Karen to get a fair trial. The judge denied the motion. The trial lasted 2 days. I testified on the first day, walking the jury through everything that had happened. My attorney presented the video footage, the police reports, and the documentation of the property dispute. The prosecutor also called the police officer who had investigated the spray paint incident, though they admitted they had no direct evidence linking that to Karen. On the second day, Karen took the stand in her own defense. It was a disaster. Her attorney tried to portray her as a dedicated community volunteer who had been unfairly targeted. But under cross-examination, Karen's true nature came through. She insisted that she had every right to enforce HOA rules as she saw fit. She claimed that homeowners who did not like it could move somewhere else. She even admitted that she had been on my property that night, but claimed she was only inspecting the snow machine to document the ongoing violation. The prosecutor pounced on that. "So you admit you were trespassing on Mr. Yates's property after midnight?" "It was not trespassing. I was acting in my official capacity." Even though the HOA had already signed a settlement agreement acknowledging it had no jurisdiction over that property. That agreement was coerced by a survey and property deed. Karen had no good answer for that. Her attorney looked like he wanted to disappear. The jury deliberated for less than 3 hours. They found Karen guilty of criminal mischief in the 3rd degree. The judge scheduled sentencing for 3 weeks later. At the sentencing hearing, the prosecutor recommended jail time, arguing that Karen had shown no remorse and had engaged in a pattern of harassment against multiple neighbors. Karen's attorney argued for probation and community service. The judge split the difference. She sentenced Karen to 30 days in jail, suspended pending 1 year of probation. Karen would have to complete 100 hours of community service, pay restitution to me for the cost of cleaning the garage door and inspecting the snow machine, and undergo anger management counseling. If she violated probation, she would serve the full 30 days. Karen looked stunned as the judge read the sentence. I think she had genuinely believed she would get off with a warning. The reality of having a criminal record seemed to hit her all at once. As we left the courthouse, Daniel pulled me aside. The HOA's insurance company reached out. They want to settle a potential civil suit before you file one. They are offering $15,000 to cover your attorney fees, costs, and damages for harassment and emotional distress. That seems like a lot. They are worried about a jury trial. With the criminal conviction and all the publicity, they think a jury might award significant damages. $15,000 is cheaper than going to trial. What do you think I should do? Take it. You have been through enough. The money will cover all your costs and then some. And you got the outcome you wanted. Your property rights are established. Karen has a criminal record and is on probation, and the HOA is under new management. I agreed. We settled the civil case a week later. Between the $2,000 from the original settlement and the $15,000 from the civil settlement, I ended up $17,000 ahead, minus Daniel's fees. More importantly, I could finally park my snow machine in peace. Life slowly returned to normal. Summer came to Alaska, and I stored my snow machine in the garage for the season. Richard Schneider turned out to be a reasonable HOA president. He focused on actual community concerns like maintaining the common areas and organizing neighborhood events, rather than obsessing over minor aesthetic issues. I ran into Tom one evening in late June. We were both mowing our lawns. He waved me over to the property line. "Did you hear Karen is moving?" he asked. "Really?" "Yeah, putting her house on the market next week. I guess having a criminal record and being the most hated person in the neighborhood was not working out for her." I felt a twinge of something, not quite sympathy but maybe pity. Karen had brought all this on herself through her own arrogance and inability to accept that she could be wrong. If she had just backed off when I presented the survey, none of this would have happened. "Well, I hope she learned something from all this," I said, Tom snorted. People like that never learn. A few weeks later, I saw a moving truck in front of Karen's house. I did not see her, which was probably for the best given the restraining order. The house sold quickly, probably because the market was hot. Some young couple with kids moved in. They seemed nice. The new HOA board held a special meeting in August to formally adopt revised rules and procedures. They sent out actual written notices to all homeowners and held a vote. The new rules included a clear process for proposing changes, requirements for written notice and homeowner votes, and an appeals procedure for violations. They also explicitly removed the snow machine restriction Karen had tried to implement. At the meeting, Richard thanked me publicly for standing up to the previous board's overreach. He said my lawsuit had been a wake-up call that the HOA needed to follow the law and respect property rights. Several other homeowners applauded. I was not looking to be a hero. I had just wanted to park my snow machine on my own property. But I appreciated the recognition. As fall turned to winter and snow began falling again in Anchorage, I pulled my snow machine out of the garage and parked it in its usual spot on the left side of my driveway. The spot that I now knew with absolute certainty was on my own private property outside the HOA's jurisdiction. Nobody complained. Nobody left violation notices. Nobody spray painted my garage or poured sugar in my gas tank. It was just a snow machine in a driveway in Alaska, exactly where it belonged. I used that machine all winter, just like I had every winter before Karen Patterson decided to make my life difficult. The difference was that now I had legal documentation establishing my property rights, a precedent for other homeowners dealing with HOA overreach, and the satisfaction of knowing that someone who abused their power had faced real consequences. The following spring, I got an invitation to speak at a community meeting about property rights and HOA governance. Apparently, my case had inspired several other homeowners in Anchorage to push back against unreasonable HOA rules. A local property rights advocacy group wanted me to share my experience. I agreed, though public speaking was not really my thing. About 50 people showed up to the meeting at a community center in downtown Anchorage. I told my story, from the first violation notice through the survey, the lawsuit, the criminal case, and the eventual settlement. I emphasized the importance of understanding your property rights and not being afraid to challenge an HOA when they overstep their authority. During the question and answer session, a middle-aged man raised his hand. What would you say to someone who is afraid to fight their HOA because they think it is too expensive or complicated? Document everything, I said. Keep copies of all notices, all correspondence, everything. Review your property documents and HOA rules carefully. You might be surprised what you find. And if you think the HOA is wrong, consult with an attorney. Many will do a free or low-cost initial consultation. Sometimes just having an attorney send a letter is enough to make an HOA back down. A woman in the back asked, "Do you regret buying a house in an HOA?" I thought about that. Honestly, no. Most HOAs are fine if they are managed reasonably. The problem was not the HOA itself, it was one person who abused her authority. The current board is great. They focus on maintaining property values and community standards without being unreasonable about it. That is what an HOA should be. After the meeting, several people came up to thank me and share their own HOA horror stories. It was eye-opening how many people had dealt with similar issues. One man told me his HOA tried to fine him for planting vegetables in his front yard. A woman said her HOA threatened to foreclose on her house over a $50 late fee. The stories went on and on. I left that meeting feeling like maybe something good had come out of my experience. If my willingness to fight back had helped even a few other people stand up to unreasonable HOAs, then all the stress and hassle had been worth it. As spring turned to summer, I finally took down the security cameras. I had kept them up through the winter, just in case, but it had been over a year since the incident with Karen, and her probation was almost over. I figured it was safe to remove them. Life in Mountain View Estates settled into a comfortable routine. Richard Schneider was re-elected as HOA president without opposition. The board hired a new management company that was much more professional than the previous one. Property values stayed stable, the common areas were well maintained, and neighbors generally got along. Tom and I became good friends. We started a tradition of having beers in one of our garages every couple of weeks, talking about sports, politics, and neighborhood gossip. He told me stories about what the neighborhood was like under the previous HOA boards before Karen's time. Apparently, there had always been a cycle of reasonable boards followed by micromanaging boards, but Karen had been the worst in the development's history. One evening in late summer, Tom asked me something I had been wondering myself. "Do you think Karen learned anything from all this?" I took a sip of my beer and thought about it. I honestly do not know. Part of me hopes she did. That maybe having a criminal record and losing her position made her realize she was in the wrong. But another part of me thinks people like that never really change. They just find new situations where they can push people around. "Probably right," Tom said. "I just hope wherever she moved to does not have an HOA, for their sake." We both laughed at that. As the second winter approached, I pulled my snow machine out again and parked it in the same spot. This time, there was a light dusting of snow on the ground, and the machine looked perfectly at home against the white backdrop. I stood there for a moment, admiring it, thinking about everything that had happened. My phone buzzed. It was a text from Richard Schneider. "Hey Zach, wanted to give you a heads up. Someone filed a complaint about a snow machine on a driveway. Not yours, different street. Board reviewed it and determined snow machines are permitted under current rules. Just wanted you to know we remembered the lesson. Thanks again." I smiled and texted back a thumbs up. It was a small thing, but it showed that the HOA had actually learned from the Karen Patterson debacle. They were not going to repeat the same mistakes. That winter was one of the coldest and snowiest on record in Anchorage. My snow machine got more use than ever. I helped several neighbors dig out after big storms, used it to haul supplies when roads were impassable, and even helped Tom get to the hospital when his wife had a health emergency and ambulances were delayed by the weather. At the spring HOA meeting, Richard mentioned these contributions and thanked me publicly. "This is exactly why snow machines are important in Alaska," he said. "They are not just recreational vehicles. They are practical tools that help us deal with our climate. The previous board lost sight of that." After the meeting, a younger couple approached me. They had bought the house 3 doors down from mine and were planning to get a snow machine. They wanted advice on which model to buy and where to park it. I walked them through the basics and showed them my property survey story as a cautionary tale. "Always know your property boundaries," I told them. "And always read your HOA rules carefully before you buy in a community with an HOA. You need to know what you are agreeing to." They thanked me and mentioned they had specifically looked for a house in Mountain View Estates because they heard it had a reasonable HOA board. That made me feel good. The neighborhood's reputation had actually improved after the Karen Patterson incident because people knew the current board was fair and followed proper procedures. As spring turned to summer again, I reflected on how much had changed in the 2 years since I found that first violation notice on my garage door. I had learned more about property law than I ever expected to know. I had stood up to an abusive HOA president and won. I had helped establish precedent for property rights in my community, and I had made some good friends in the process. Tom and I were sitting in my garage one evening, beers in hand, when he brought up something I had not thought about in a while. "You know, Karen's probation must be up by now," he said. "Think she ever paid you that restitution?" "Oh yeah, got the check about a year ago. She had to pay for cleaning my garage door and having my snow machine inspected for damage." "How much was it?" "About $800. Not much in the grand scheme of things, but it was the principle of it. Whatever happened with the other neighbors she harassed? The guy with the slashed tires and the couple with the dead garden?" "I do not know about the tire slashing. I think they could not prove it was her. But the couple with the garden, I heard she had to pay them restitution too as part of a civil settlement. Their garden had been pretty extensive, cost them a few thousand to replace everything." Tom shook his head. "All that trouble over things that did not matter. Basketball hoops, door colors, snow machines. What was wrong with her?" "Some people just need to control everything around them," I said. "And when they get a little bit of power, like being HOA president, they go crazy with it." "Well, I am glad you fought back." "Things are a lot better around here now." I agreed. The neighborhood had a completely different feel under Richard's leadership. People were not afraid to decorate their homes or park their vehicles or plant gardens. The HOA focused on actual community concerns like fixing roads, maintaining street lights, and organizing neighborhood events. It was what an HOA should be. A few months later, I got an unexpected call from Daniel Wright, my attorney. We had stayed in touch occasionally, but I had not needed his services since the settlement. "Zach, I wanted to give you a call because something interesting came across my desk. Karen Patterson is being sued by the HOA in her new neighborhood." "You are kidding." "Nope. Apparently, she moved to a development in Eagle River and managed to get elected to their HOA board. She started up the same behavior, issuing questionable violations and fines. One homeowner pushed back, and it turned out Karen had been embezzling HOA funds to pay her legal bills from your case." I was stunned. "Are you serious?" "Dead serious. The HOA hired a forensic accountant who found about $12,000 missing from HOA accounts. They have filed a civil suit to recover the money, and I heard the district attorney is considering criminal charges for embezzlement." "That is insane. She had a criminal record and was on probation, and she still managed to get elected to another HOA board. Apparently, she did not disclose the criminal conviction. That is probably going to be another legal problem for her." After I hung up, I sat there processing this information. Part of me was not surprised. Tom had been right when he said people like Karen never learn, but part of me was shocked that she had escalated to actual embezzlement. That was a whole different level of criminal behavior. A few weeks later, the local news picked up the story. The same reporter who had covered my case did a follow-up piece about Karen's new legal troubles. They interviewed me briefly, and I expressed surprise, but noted that it showed the importance of HOA board members being held accountable. The reporter also interviewed Richard Schneider, who said the Mountain View Estates HOA had implemented new screening procedures for board candidates, including background checks. He said they wanted to make sure they never had another Karen Patterson situation. The story prompted several other news outlets to do features on HOA abuse and embezzlement. It became a minor scandal in the Anchorage area, with several HOAs announcing reforms and increased oversight. Karen was ultimately charged with theft in the second degree, a felony, for embezzling the HOA funds. Because she was still on probation for the criminal mischief conviction from my case, she also faced a probation violation. I did not follow the case closely, but I heard through the grapevine that she accepted a plea deal. She got 2 years in prison, to be followed by 5 years of probation. She also had to pay back all the money she stole, plus interest and penalties. It was a stunning fall from grace for someone who had just wanted to be in charge of neighborhood aesthetics. If Karen had just let people park their snow machines in peace, she would have finished her term as HOA president and moved on with her life. Instead, her need for control and her inability to admit when she was wrong had led to a criminal record, jail time, and financial ruin. I felt no satisfaction in her downfall. If anything, I felt sad that someone had let their worst impulses destroy their life. But I also felt vindicated. I had been right to stand up to her, right to fight back against her abuse of authority, and right to insist on accountability. As the years passed, the Karen Patterson story became something of a legend in Anchorage HOA circles. I would occasionally meet people at community events who would hear my name and say, "Oh, you are the snow machine guy." It was a strange kind of fame, but I did not mind it. If my story helped other people recognize HOA abuse and fight back, that was a good thing. Tom and I still have our regular garage beers. The neighborhood is thriving under reasonable HOA leadership. My snow machine still sits in the same spot every winter, on my private property, outside HOA jurisdiction. And every time I look at it, I am reminded that sometimes standing up for yourself is hard, but it is worth it. The whole experience taught me several important lessons. First, always know your property boundaries and review your property documents carefully. You might be surprised what you find. Second, HOAs are only as good or bad as the people running them. A bad board can make life miserable, but a good board can actually improve a community. Third, do not be afraid to challenge authority when it oversteps its bounds. The law is on your side if you are right. And fourth, some people should never be given power over others. Karen Patterson was one of those people. Her reign as HOA president was mercifully short, but the damage she caused took years to undo. The fact that she tried the same thing in a new neighborhood and escalated to embezzlement showed that she had not learned anything from her first criminal conviction. But the system worked, eventually. She was held accountable, both civilly and criminally. The homeowners she harassed got justice. And the HOAs she tried to control implemented reforms to prevent future abuse. 3 years after that first violation notice appeared on my garage door, I was invited to serve on the Mountain View Estates HOA board. I declined, joking that I had seen enough of HOA politics to last a lifetime. But I appreciated the offer. It showed that the neighborhood valued my willingness to stand up for property rights and reasonable governance. Tom ended up joining the board instead. He was elected treasurer and immediately implemented new financial controls and transparency measures. He said he was thinking about the Eagle River embezzlement case and wanted to make sure nothing like that could happen in our neighborhood. Life is good now. The HOA functions smoothly, enforcing reasonable rules without harassing homeowners over trivial matters. Property values have increased. The neighborhood has a real sense of community, with regular events and neighbors who actually know each other. And every winter, when the first snow falls and I pull my snow machine out of the garage, I park it in that same spot on the left side of my driveway. The spot that is legally, definitively, unquestionably my private property. The spot that is outside HOA jurisdiction, as confirmed by survey, deed, settlement agreement, and court precedent. Sometimes I stand there for a moment, looking at the machine, remembering everything that happened. The violation notices. The angry phone calls, the lawsuit, the vandalism, the criminal trial, the settlement, all because one person thought she had the right to control where I parked my own property on my own land. But then I start up the snow machine, the engine roaring to life in the cold Alaska air, and I head out into the winter landscape. Because that is what snow machines are for in Alaska. Not causing HOA disputes, not violating imaginary rules. Just living life in a place where winter is 6 months long, and sometimes you need more than a car to get around. And that is exactly what I told Karen Patterson from the very beginning. If she had just listened, if she had just checked the property boundaries, if she had just been reasonable, none of the rest would have happened. But she did not listen, and she paid the price for it. As for me, I am just a guy who wanted to park his snow machine in his driveway. I never wanted to be an HOA reform advocate, or a local news story, or a cautionary tale about abuse of power. But sometimes life pushes you into situations you did not ask for, and you have to decide whether to fight back or give in. I am glad I fought back. Not just for myself, but for all the other homeowners who were being harassed by Karen Patterson and did not know they had options. Not just for my neighborhood, but for the precedent it set about HOA limitations and property rights. And not just for the principle of it, but because sometimes standing up to a bully is the right thing to do, even when it is hard. The snow machine is still there, on my driveway, exactly where it belongs. And it will stay there every winter for as long as I own this house. Because it is my property on my land, and nobody has the right to tell me otherwise. That is the real victory. Not the lawsuit or the settlement or the criminal conviction. The real victory is knowing that I stood up for myself, I was right, and I won. The real victory is living in a community where property rights are respected and HOAs are held accountable. The real victory is being able to park my snow machine in peace, without fear of harassment or retaliation. And on those cold winter mornings when I fire up that machine and head out into the Alaska wilderness, I am reminded of why I bought this house in the first place. Not for the HOA drama, not for the legal battles, but for the freedom to live my life the way I want to live it in a place I love, without unreasonable interference from people who think they know better. That is all I ever wanted. And that is exactly what I got, though it took a survey, a lawsuit, and a criminal trial to get there. But it was worth it. Every difficult moment, every angry phone call, every legal document, every dollar spent on attorneys. It was all worth it to establish the principle that my property is my property, and nobody has the right to abuse their authority to tell me otherwise. The snow machine sits there now, covered in a light dusting of fresh snow. Tomorrow I will brush it off and take it out again. The same routine I have followed every winter since I moved here. The same routine that one person tried to stop and failed. That is how this story ends. Not with a dramatic confrontation or a last-minute twist. Just with a snow machine in a driveway in Alaska, exactly where it belongs, and the quiet satisfaction of knowing that justice was served and rights were protected. Because that is what this was always really about. Not HOA rules or property surveys or legal technicalities. It was about the fundamental right to use your own property as you see fit, as long as you are not harming anyone else. It was about standing up to people who abuse positions of authority. It was about refusing to be bullied, no matter how much easier it would have been to just give in. I did not give in. I fought back, and I won. That is the story of how my HOA banned snow machines on my driveway, and a survey proved it was private property. That is the story of Karen Patterson's fall from HOA president to convicted criminal. That is the story of one neighborhood's transformation from micromanaged subdivision to thriving community. And that is the story of one man's refusal to accept injustice. No matter how small or trivial it might seem, the snow machine is still there, and it always will be.